divorce, separation of marriage, annulment of marriage, three of them bring a marriage to an end somehow, or one way or the other. My name is Legalservices. I'm a partner at a solution law firm, and I just want to briefly talk about divorce, separation of marriage, and annulment of marriage under Nigerian law. The most common of these three, what is so common about these three matrimonial matters I've mentioned is the fact that they bring the marriage to an end. Dissolution of marriage, called divorce as well, is a process of ending a valid marriage, whereby the marriage ceases and the other party can remarry after the dissolution of marriage has been completed, where the order of the custody can be given if there are children involved in the marriage, and where there could be separation of distribution of property, also known as a settlement of property, among others. However, on the other side, separation of marriage, that often called judicial separation, if it goes through the court process, is a process whereby by an agreement of parties or by order of the court, a marriage, the couple of a marriage separated by probably not living together, but it goes beyond that, by also showing the clear intention or through the judicial order stating that the parties are separated. Technically, if parties are separated, the marriage can be said to have somehow ended, but it has not been ended. The marriage is still there, is still subsisting. Neither of the parties who have separated can remarry. So separation or judicial separation should only be explored if the parties, they are no longer interested in marriage again. They just want to be separated from one another. Or the party just want to temporarily separate, whereby they are considering the future, maybe perhaps when the tension is down, they can still remarry. Then the third one is annulment of marriage. What do we call annulment? It's a process of bringing to an end a marriage that most times have been issue, not valid, or the marriage that can be made to be voided by the fact of the things that are called or before the marriage, which this kind of marriage we call them kind of circumstances we talk about voidable marriage. Some marriage are void ab initio, which means as at the time that marriage was conducted, the marriage ought not to have been conducted. An example is a marriage to somebody below the age of 18. That marriage ought not to have been conducted. It's void ab initio. Then a marriage whereby one of the parties are already legally married to someone else. That marriage ought not to have occurred in the first place. It's void ab initio. You can file an order of the court for annulment of marriage, so you can seek a pronouncement of court to state that this marriage is void. Although it's void ab initio, the order of the court might not be required, but it will be required where there have been official records. For example, where someone has already shown everywhere that, oh, I was married to this person. It is not enough to state that, oh, the marriage was void ab initio without any judicial order. There should be an order of the court that clearly stipulates that that marriage is void ab initio. And that's the process we call annulment. But there are some marriages whereby it became voidable as a result of what happened during that marriage or prior to that marriage that the other parties couldn't see or didn't know. For instance, if one of the parties had a mental issues prior to the marriage, if it's not within more than a year after that marriage, it has made that marriage to become voidable. If another instance of a voidable marriage is if you marry to someone that's somehow related to someone, there are different levels of that I cannot really, I don't really have much time to explain now. And you discover that it has made those marriage voidable. By then, those kind of marriage, they are not void ab initio. They are voidable marriage, which means the judicial order, the order of the court, will be required to void those marriages. And in those instances, you also need to file a petition for nullity of marriage that we can also call annulment. So you could see that divorce, often called the dissolution of marriage, separation of marriage, also known as judicial separation. I mentioned separation of marriage earlier, and I talked much of it about court, but it's not in all circumstances that a court have to separate parties. Party may decide to involve a lawyer to draft a separation agreement where they agree on most of the times, and both of them sign it. If they can do that gently, peacefully, they don't need a judicial order. Party can sign and be separated. But it is when, in most cases, that we've seen that parties could not sit down and agree on something, but they still don't want to divorce yet, and that is why they will come to they will have to file for a petition for judicial separation in court. So all these three elements: dissolution of marriage, which is not divorce, separation, and nullity of marriage, also known as annulment, they somehow bring a marriage to an end to an extent. But then you can see that they have different reasons, different distinctions among them. Three of them, they are not the same. They look similar. They look close. And it's possible for one person to qualify for the two. It's possible. So if your circumstances, your case is qualified, or you intend to do judicial separation, you intend to do the divorce, you must take one at a time. The law does not permit you to go into court and say, I want to do the two together. You take one at a time. It's either you file for a separation first, or you file for dissolution of marriage first. You say one at a time, and three of them, they are originated by petition, and they must be filed or be done at the High Court of the state within Nigeria, or at the High Court of the federal capital. The purpose of three of them is to somehow bring the marriage to an end, but they have some little differences. Thank you. See you again.